example also, in difference-based questions also you can write down the examples. As I gave you example highlighting the difference. If you disallow somebody to enter into his house, it is wrongful restraint. And if you do not allow anybody to come out of his house, it is wrongful confinement. So you please do quote this example. Very relevant. Very simple. Read first illustration A causes Z to go within a walled space and locks Z in. One person. A causes Z to go within a walled space and locks Z in. Z is thus prevented from proceeding in any direction. He cannot go in any direction beyond the circumscribing line of wall. A wrongfully confines. Imprisoning someone somewhere. And second example is A places men with firearms at the outlet of a building and tells Z that they will fire at Z if Z attempts to leave the building. A wrongfully confines Z. There is no imprisonment in this case, there is no war in this case, but even then he is confined. You may confine a person in running car, in moving train also. That's why I said prison may be static or it may be walled or without wall. It may be in a closed room, it may be in open field. What is imprisonment? What is confinement? Consequence on your liberty. When you are not allowed to go anywhere, complete, like house arrest, it is wrongful confinement if it is without authority. If it is with authority of law, then there is nothing wrong. If it is without authority of law, then it is wrong. I see punishment very simple. The 41 says 1 month, wrongful confinement 1 year. See the difference in gravity. 1 month and 1 year. You might be also aware that India is a liberal democratic country. In liberal democratic country, individual liberties are paramount importance. So whenever you interfere with liberty of someone, law takes it very seriously. That is why I have told you in the beginning of this discussion that in these offences which are liberty related, intention is not required to be proved in similar way as in injury related offence. The law is stricter. The requirement is lesser. And that is why many people will say these are stricter offences. But the stricter offences does not mean that it is without mens rea. In this case, it is mens rea. Voluntarily obstructs. It is written in 339 itself. Voluntarily is intentionally, knowingly or having reason to believe. That is the set of mens rea. Wrongful confinement for 3 or more days. And injure more, punishment more. 3 or more days, 2 years. 10 or more days, 3 years. Wrongful confinement of person for whose liberation writ has been issued. Already it has been issued, said that you please release this fellow and you are not releasing. You are keeping him. It shall be punished with 2 years. Liberation has been released shall be punished with imprisonment of either discretion for a term which may extend to 2 years, in addition to any term of imprisonment to which he may be liable under any other section. So if you are confined in a then the punishment is 2 years already, and then liberation writ has been issued, so for this additional 2 years. So 2 plus 2, 4 years in addition. Wrongful confinement in secret, again 2 years. Wrongful confinement to extort property or to consent to illegal act, 3 years. Wrongful confinement to extort confession, again. You can be asked only a difference-based question. You can substantiate, support, supplement this discussion with the help of false imprisonment in practice. False imprisonment also requires total restraint, as wrongful confinement requires total restraint. So you can write down in wrongful restraint that it is partial restraint, whereas wrongful confinement is total restraint. So you can frame a very good question. Wrongful restraint is partial, whereas wrongful confinement is total. Critically examine this way. Critically examine this way, or discuss this with the help of examples. आप एग्जाम्पल भी लिख सकते हैं. प्रिंसिपल को यदि प्रिंसिपल के कमरे में बंद कर दिया जाए तो कन्फाइनमेंट, और प्रिंसिपल साहब को अपने ऑफिस में ना जाने दिया जाए तो रिस्ट्रिक्ट. बहुत एप्ट इलस्ट्रेशन दिया. नहीं, आपकी मर्जी प्रिंसिपल साहब ने डालना पड़ा, बंद करो कमरे में, तो कन्फाइनमेंट हो जाए. ना साइन कर पाए आपका कोई डिसिप्लिनरी डॉक्यूमेंट तो रिस्ट्रेंट करेंगे, कमरे में जाने नहीं देंगे. इज दिस क्लियर? हाँ बिल्कुल. स्टेट लेवल कॉलेज का आप मेन गेट ही बंद कर देते हो, दिस इज रिस्ट्रेंट. देयर इज नो अदर एंट्री पॉइंट. दिस इज रिस्ट्रेंट. एंड कॉलेज में सबको बंद कर देते हो, कन्फाइन. यस, आज फैकल्टी नहीं. इफ देयर इज रीजनेबल एस्केप देन देयर इज नो कन्फाइन. Then there is no confinement. It should be within 4 walls. It should be in circuit place. That is what I have said. Circumscribing. That is the restraint. नहीं, यहाँ पे नॉलेज से कोई मतलब नहीं है. नॉलेज और नॉन नॉलेज. Even in tort law, it doesn't matter much. In tort law also, he is raising the question whether it is necessary for the victim to know that he is being restrained or he is being confined. So I am saying that in criminal law, knowledge does not have any value because it is nowhere been taught. But as far as in civil law it is concerned, tort law it is concerned, there knowledge is again not so relevant, but it may be relevant in assessing the quantum of damage. In many cases, people will not know that it is imprisoned. Like in Fenn, he will never know, but he also has fundamental freedom. He also has right to liberty. Insane person, he will never know that he is being imprisoned. And he also has fundamental right of freedom. If you know this, that you are being imprisoned, injury is graver. Quantum of damage is more. You read in tort law, mirroring case and hearing case. There are 2 cases. Mirroring and hearing. And then there is 3rd case, Murray. As you have asked, I have answered. So it is not relevant here. But mirroring, hearing and Murray, 3 cases are there. Is this all right? Now let us come to another. Criminal courts and assault.